Okay, welcome everyone to the Judiciary Committee meeting this Wednesday morning. We have several agendas today. We have two at 9:30, which is my fault. We have one at 9:31, and we have one at 10. So we'll start with the 9:30, the decision-making only agenda. So the first item on that is Judiciary Communication number 23, submitting for consideration and confirmation to the District Court of the First Circuit Shelley Kate Parko Appealee for a term to expire in 6 years. Members, the recommendation on this one is to only hesitating because I can never remember the right phraseology. Consent to the appointment.
Advise and consent.
Questions or concerns? If not, Senator Casio.
Okay, members, we are voting on JC 23 to consent. Chair Rhodes.
Aye.
Senator Keoho Kalole, excused. I vote aye. Senator Gabbard.
Aye.
Senator Kim. Aye. Senator Lee. And is excused. Senator Keoho Kalole for
Aye.
JC 23. And Senator Favela is excused.
Okay, thank you.
Chair.
Congratulations.
Adopted, Chair. Yes.
Next up is Judiciary Communication number 24. This is for consideration and confirmation to the District Family Court of the First Circuit for Natasha R. Shaw for a term to expire in 6 years. Again, the recommendation is to consent. Questions or concerns? If not, Vice Chair.
Members voting on JC 24, the recommendation is to consent. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee is excused. Senator Favela is excused. Recommendation adopted.
Thank you very much. Congratulations to you both. And your full Senate votes will be next week, I guess.
Tuesday.
Probably Tuesday the 12th. Okay, thank you very much. Okay, moving on down the same agenda to HB 1888. This relates to electioneering communications. Increases the amount that requires disclosure of electioneering communications, requires the disclosures of electioneering communications occur on the date the electioneering communications are publicly distributed. And keep in mind that this is for non-candidate committees only. Recommendation here is to pass with an amendment. We had some discussion about mailers the other day, so we're going to put in an exception for mailed electioneering communications. You have to file the report on the date the communication was mailed. So it won't be when it arrived. We won't try to make them figure out when it's arrived. And we'll leave the date bad as well. Questions or concerns on HB 1888? If not, Vice Chair.
Members voting on HB 1888 HD2, the recommendation is to pass with amendments. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee.
Aye.
Senator Favela is excused. Recommendation adopted.
Okay, thank you very much. That brings us to the conclusion of our first agenda, so we're adjourned on that one. Austin, do we need to count down again for the second 9:30? We'll keep going. Move on to the other 9:30 agenda, which was a continuation of a hearing we were having on HB 1453 that specifies that refusing to provide identifying information to a police officer when being detained for a traffic offense is a petty misdemeanor. I believe we had completed taking initial testimony. Okay, and so if there are people here on Zoom or on in person that are here to answer questions, we can ask questions of them. Is anybody here for that purpose?
Good morning, Chair. This is Braden Ogata. I'm here from HPD. I'm able to answer any questions you might have. Thank you.
Great. Okay, great. I'll public defender as well. So members, any questions? So I guess for HPD, there is a crime, I believe, of unsworn falsification to a law enforcement officer or a public official. I forget what the exact phraseology is. Is that not something you can use in this situation?
I don't believe so, sir, in this particular case. This is specific to the traffic violation section. So we always will look to this particular violation if this should come up.
Okay, so, all right, so a different question in terms of, I think your testimony was that you want to be able to arrest the person so you can take them back to the police station so you can have a better chance of determining who they really are. Is that correct?
And identifying and basically having a progression if they refuse to provide any info. Because currently right now we're stuck if we have to try to give them a citation and they won't give their name.
What if you were allowed to detain them briefly at the location? Does that give you enough time or the technical feasibility to determine who they are? It's similar to a Terry stop where you have to have some reasonable suspicion.
Yes, sir. We do actually make every effort to work it out in the computer, out on the road. As I did mention previously, it's not an ideal to have to arrest people for this stuff. We're very short on staffing, and this is when we're doing traffic enforcement, we want to address the violation for jaywalking or whatever it may be and move on. We also don't want to be detaining people any longer than is absolutely necessary to complete that traffic stop interaction. So no, sir, to be honest, that wouldn't be what we would want to do to detain longer. It wouldn't help us.
So what you're saying is that at this point you can detain them for a few minutes anyway to run things through the computer. Run
the things through the computer or issue a citation in a normal circumstance. Yes.
Okay. All right. Let's see. I don't know what this is license right here. Leslie, any other questions I should be asking? Are you on?
Yes, Chair, I'm here.
I think those are the ones that we discussed that were of interest. Is there anything else?
No, Chair, that is correct.
Okay. All right, thank you. Members, any other questions? Members, for the recommendation on this, I don't feel like it's ready. I have questions about there's a long history of asking people for IDs, and I'm not sure. I sympathize with the police officers, and it's certainly an issue I'd like to come back to next year if I'm still, if I'm reelected. But I don't think it's ready, so I'm going to defer it. All right, that concludes. We adjourn that 9:30 agenda, and then we have. Thank you for coming back, everyone who came back. I appreciate it. Then we have a 9:31 agenda. It's actually a hearing. This is. Do I need to go through the?
It's the same Zoom.
It's the same Zoom. Okay, we'll keep going then. So for our 9:31 agenda, first up we have SCR 54/SR 49 requesting the judiciary permanently provide an option allowing petitioners of temporary restraining orders to remotely testify for those hearings. First up on this measure is Andrew Park for the judiciary. Good morning.
Good morning, Chair Rhodes, Vice Chair Kalole, honorable members of the committee. I'm Andrew Park from the Family Court First Circuit. I will stand on our written testimony and be available for any questions if anyone has any questions.
Good, thank you very much. Next we have Angelina Mercado for Hawai'i State Coalition Against Domestic Violence. Good morning.
Good morning, Chair, Vice Chair, and committee members. Angie Mercado, the Executive Director of the Hawai'i State Coalition Against Domestic Violence. I stand on my written testimony in strong support of this measure with amendments for clarification. I would like to add that this is one of the few measures in this entire session that would have an immediate impact on the safety of survivors of domestic violence. This committee in particular has heard many bills throughout the years that would have an impact on survivors. We know that these are complex issues. We know that there are systemic measures that need to be taken to support survivors. And I dare say this is one of the few that would actually have an impact that we would be able to see immediately. I know that the judiciary has some concerns about credibility determinations about when you have persons live in person as opposed to doing remote testimony. And again, I want to point the committee members to the Committee of Chief Justices Conference and State of Court Administrators that recommended this is a measure and a practice across the country that has become permanent. And I think that we all have the ability to advanced with technology, and all of us have come up to speed to address the needs of our community. Our survivors and our advocates have been able to work incredibly using technology for remote advocacy, remote testimony, remote hearings. And I think it's just a matter of course that we all modernize and catch up with best practices to ensure safety of survivors of domestic violence. I am here and available for any questions you may have. Thank you for this opportunity to testify and for hearing this measure.
Thank you very much. Members, I'm going to have to take a short recess. Just one moment. Recess. Next testifier on SCR 54, SR 49 is Nancy Creedman from the Domestic Violence Action Center. In support, El Basha. In support, Kanoe Lani Ruiz. In support, Jordan Maston. In support, Jamie Lynn. In support, Cara Chapola Carulas, Executive Director for Hawaii State Commission on the Status of Women. In support, Karen Tan. In support, Renee Hamilton Combio. In support, and Karen Holt. In support. That's for both some of them testified just on SR 49, some just on SR 54, I mean SCR 54. Okay, members, any questions? Oh, is anyone in the audience that wanted to testify on these measures? Oh, via Zoom, I'm sorry. Okay, go ahead. I'm sorry. I can't tell who you are. I'm sorry. Go ahead.
Well, aloha, Chair, Vice Chair, and committee members. My name is Sonoka Aihui. I'm the Executive Director for Women Helping Women. We are primarily based in Maui County, and we operate on the islands of Maui and Lanai. And I am in complete support of moving this forward and keeping this as a permanent option for survivors. As a survivor myself, I understand the court process and how terrifying that can be, to be in a courtroom with your abuser sitting less than 15 feet away from you. I can tell you that you have no idea what you're going to say. And so giving petitioners the option to stay in a safe place, whether that be an advocate office or in the privacy of their own home, to be able to gather their thoughts, share their heart, and actually speak to the abuse that's been happening to them and be honest with that safety and support around them has made such a huge impact for our survivors, especially during this time of the pandemic. We have many rural areas. We have an office in Hana, and if you've ever been to Hana, it's probably about a 3.5-hour drive back into town. And that's just to get you to your court hearing. So we've had many survivors that have been able to stay in Hana and actually have their hearing through our office. And that has made a huge impact with the amount of survivors that are actually coming forward at this time. And so I just urge you guys, and I strongly, strongly support this continuing into being a permanent status for survivors. So thank you very much.
Thank you. I think that's all the testifiers we have. Anyone else wishing to testify on these measures? If not, members' questions? For Women Helping Women. So the initial filing for a TRO in the legal jargon is ex parte, which means that you can just send it in without the other party being there. That's correct. Is that correct?
That's correct.
So the part of it that you're really concerned about is the subsequent order to show cause, where I mean, I think the statute actually says that everybody's supposed to be present.
That's correct. Yeah.
Okay.
So
it's really the order to show cause hearing that you're worried about.
that's right.
Okay, thank you. For the judiciary, so HRS 586.5 says all the parties have to be present. And I think it uses that word present. From your testimony, it sounds to me like the judiciary has interpreted that as being present in person. Is that correct, or is there some wiggle room there?
There is currently a mechanism where petitioners or parties, petitioner or respondent, typically petitioners can file a motion for a remote appearance in the First Circuit. Especially during the pandemic, we saw an uptick in those motions. A lot of times those motions would come in at the ex parte TRO application phase, and the judge would be able to review that and authorize a remote appearance for that petitioner at the order to show cause hearing. And that mechanism will continue to exist even when the pandemic is behind us, and parties will be able to seek leave of the court, and the court can and will continue to grant those requests.
For what reasons were judges allowing that to happen?
Allowing the remote testimony to
Yes.
happen. During the height of the pandemic, in the spring of 2020, for example, it was primarily the COVID concerns, right? Having people out in public in the courthouse, because the TRO calendar, as was written in our testimony, was one of the main calendars that continued on in person throughout the pandemic.
So generally that meant that it was not for safety reasons.
If there was a safety reason that was explained in the motion, that could be considered and that could be granted. And in the testifier discussed, the Second Circuit has a unique set of issues as well, with different islands comprising the circuit. And that could be something that a family court judge and that circuit could take into consideration with regards to, the Na'i, Kapi, etc. So there is a variety of reasons.
So the rule is not the same in the second and the first, or it's not the same in all the circuits?
It would be that the judge would be able to have a motion before that judge or a request before that judge, and be able to look at the circumstances of that particular case and that particular request and be able to grant it if it's appropriate.
Okay, but then if that's the case, then that means that being present has not been interpreted as necessarily being there in person. Because
Certainly,
your testimony basically says it's really, 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 really important that everybody be there in person, but then you're saying that it's not really important.
it's really important for them to be in person to have the best measure of the judge being able to determine credibility. But if it is not feasible or not possible, or, there's a reason that the court can look at and can use as a basis to grant a motion for remote appearance, and the judge could do that.
But isn't there almost always a reason? I mean, if somebody's life is in danger, isn't that a good enough reason?
Certainly that would be something that the judge would look at and I imagine could consider.
Okay. All right, members, any other questions? Okay, thank you very much. Thanks for being here.
Thank you, Chair Rhodes.
We'll go ahead and
Thank
move
you,
on
Vice
to the
Chair.
next item on the agenda, which is a governor's message number 592, James Gashel, submitting for consideration and confirmation to statewide voters with special needs advisory council for a term to expire June 30, 2023. First up from Mr. Gashel is Donald Sakamoto for the National Federation of the Blind of Hawaii.
Not present, Chair.
In support, Ann Limke. Also in support, Glenn Takahashi for the City and County of Honolulu, the Office of the City Clerk. In support, Daintree Bartolus, Executive Administrator, testifying for Hawaii State Council on Developmental Disabilities. In support, Louis Erditchik, Hawaii Disability Rights Center. In support, Kirby Shaw, Executive Director, Disability and Communication Access Board. In support, Virgil Stennett for National Federation of the Blind of Hawaii. In support, Brandon Young. In support, and that brings us to the nominee himself. Would you like to come up and make an opening statement? Good morning.
Thank you, Chair Rhodes and Vice Chair Keokloli and members. I really appreciate the opportunity to appear here this morning. It was an honor to be nominated. It's an
I'm
honor
sorry
to be
to
before this committee.
interrupt already. Can you, if you can see the mic, pull it. Yeah, there you go. Perfect. Thank you.
Okay, fine. It was definitely an honor to be nominated. It's an honor to be before this committee. If you give consent, it'll be my privilege to serve. I really can't think of a better way to give back than to help to improve the election process, especially at these days and times in our country, but also in our vote by mail system, which is very, very good. It is a challenge for people with needs that aren't anticipated by the system. I look forward to serving on this committee to help to address these needs, and mahalo for your consideration.
Thank you. Members, any questions? Mr. Gashel. Would you, I have a question at least. So are there specific things that you hope to accomplish on your, whatever it is, a year and a half on the board?
Well, one of them certainly is to make sure that the legislation that was enacted last year, which allows for electronic return of voted ballots, is fully implemented. This means that so in the case of people who are blind or some others with manual dexterities, signing the envelope and making sure you sign in the right place and with a signature that can be replicated over time, et cetera, et cetera. You can't read my signature, I guarantee it. I can write it in Braille for you and I'll read it. But my point is, the law now allows for the electronic return of ballots with an electronic means of authentication. And if I could have one wish, it would be really good implementation of that provision.
Okay, thank you very much. Members, any other questions? Okay, thank you, Mr. Gashel, for being here. Members, you okay to go straight to decision making? Okay. Find my paperwork here. Now, on the first one, I'm very sympathetic. I think that I think if we're going to really accomplish anything on this one, we're going to need to change the underlying statute. So, I mean, if the judiciary has already testified that they have the inherent authority to allow people to testify remotely if they want to. This is not a criminal case, so the Sixth Amendment and stuff do not apply. But I think what I'm going to do is defer this with the commitment to look at it over the interim and look at the underlying statute and maybe make it so that it's mandatory, at least in certain situations, that the petitioner can appear remotely. So I'm going to defer.
It's just a resolution.
Sorry.
I'm talking about SCR 54.
I'm sorry, I didn't make that clear. Yes, SCR 54 and SR 49.
It's just a resolution, the first thing, right?
Yeah, and I just don't think it'll do anything. So that's why I'm deferring it. Moving on to Governor's Message 592 for James Gashel, submitting for consideration and confirmation to statewide voters with special needs special advisory committee for a term to expire 6/30/2023. Recommendation here is to advise and consent. Questions or concerns? If not, Vice Chair.
Members voting on GM 592, the chair's recommendation is to advise and consent to the nomination. Noting the excused absence of Senator Favela, members, are there any reservations or no votes? Seeing none, recommendation adopted.
Okay, thank you very much. Congratulations, Mr. Gashel, and your Senate vote will be forthcoming. I'm not sure exactly when. Well, that brings us to the end of our 9:31 agenda, so we'll adjourn out of that. I believe we have one further agenda at 10 o'clock, so we'll have to wait a few minutes for that. All right, so we're adjourned for the moment. Okay, welcome everyone to our Judiciary Committee's 10 o'clock agenda. We have one item that we need to reconsider and vote on again. We thought we were passing it out with a good date. In fact, we were passing it out with a bad date. So the recommendation is to reconsider and change the date to effective upon approval. Questions or concerns? I'm sorry, I forgot to say what it was. This is relating to highway safety. Just clarifies the definition of drug, substance, and substance abuse for purposes of operating a vehicle under the influence of an intoxicant. And it's HB 2337. My apologies. So the recommendation is to reconsider and pass with a date effective upon approval. Questions or concerns? If not, Vice Chair.
Members voting on HB 2337 HD1, recommendation is to reconsider the previous decision and pass with amendments. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee.
Aye.
Senator Favela. is excused, recommendation adopted.
Thank you very much. We're adjourned.